Hello, everyone, and welcome. My name is Tricia Richardson, and we are here today. I'm an account executive at AN, and today we are here with MSCI to do this webinar on harassment in the workplace and risk avoidance and transfer. AN, as a member of MSCI, strives to share thought leadership that we believe is of value with other MSCI members. We are proud today in partnership with Jackson Lewis to share insights on a topic that recent events have brought an even greater level of awareness to. Today's discussion will be led by Tom Hands, Samantha Manfredini, and John Corda. Tom Hands is our National Employment Practice Liability Insurance Practice Leader and works with AN clients in the Financial Services Group to advise of legal and claims trends and market development, assist with the renewal strategy, directly assist in preparing clients for the marketplace and marketing their account on complex placements, and ensures that the best terms and conditions are achieved relative to employment practices liability insurance. Samantha Manfredini is also a member of the AN Financial Services Group, where she is the Assistant Employment Practices Liability Practice Group Leader. In that capacity, she monitors EPL and wage and hour litigation, settlement statistics, and regulatory changes. Samantha is also one of the main authors of a corporate publication distributed 4 times a year detailing claims and market updates relating to both EPL and wage and hour issues. John Corda is a principal in Jackson Lewis's New York City and Long Island offices. John is an employment litigator who dedicates a significant amount of his practice to assisting employers in reducing the risk of employment litigation through preventive practices such as training and policy review. We thank you for your participation, and we do encourage questions throughout and at the end of the webinar. And with that being said, I'm going to pass it over to Tom to discuss why we are here and what we will cover.
Great, thank you very much, and thanks everyone for attending. Again, I mean, it's almost like the story tells itself from the headlines, right? I mean, that's the reason why we've got such great attendance from your folks, and there's such heightened interest right now because of such focus on this issue of harassment in the workplace. And the goal of this presentation is to, again, share some of the stats we've seen in recent past around these issues, and then ideally focus on some best practices that John can focus on for us around things that you should be thinking about and doing to try to reduce your risk. And then we will close out with a focus on the insurance itself, how it operates, and some of the related services around that, with a goal of not just transferring the risk, but also kind of hoping to teach you how to avoid the risk. So with that, I think I'm going to hand it back to John very briefly to give a couple of the stats, and then we'll move on from there.
Yeah, I mean, thanks. This is John. Just to let everyone know the history of where we are, how we got to where we are today. You know, I've done I did training with a lot of young people on the line, and a lot of them said, well, where did all this harassment in the workplace, where did these issues come up? And everyone seems to think this all started with Harvey Weinstein. Although what I like to call, we now live in the post-Harvey Weinstein workplace, there's a history. This is not the first time that there's been such a focus on harassment in the workplace. Just a brief history. 1975 is when it started, right? That's a Working Women United rally in New York City. The first time that the United Nations basically said that 1975 was the year of the woman. 1977, we have Miss Magazine. Miss Magazine, for the first time ever, did we have a journalist to talk about sexual harassment in the workplace. And, you know, shortly after that, we fast forward to 1986, the seminal case of Meritor Savings Bank. Meritor Savings Bank was the first time that the Supreme Court actually recognized sexual harassment, hostile work environment as illegal. Prior to that, it wasn't illegal. Interesting, right? The civil rights statutes were passed in 1964, but not until 1986 was harassment actually unlawful. Then, you know, what I like to see, fast forward to 1991, I think Anita Hill really started it all. Right, Anita Hill really brought to the forefront harassment in the workplace in connection with the confirmation hearings with Clarence Thomas. After Anita Hill testified before Congress about her experiences with Clarence Thomas, those experiences were somewhat sexually charged and they weren't the most positive of experiences. But after that, there was a 50% increase at the Equal Employment Opportunity Commission of sexual harassment charges. That's really where the birth of these types of harassment claims came up. 1998, in the wake of this huge increase in harassment lawsuits in the United States, the Supreme Court issued a decision where it provided employers with defenses to sexual harassment claims. And basically, just summarizing that defense is that there is a defense if an employer has a policy and trains its managers and takes affirmative steps to prevent harassment in the workplace. That's why what we're talking about today is very important, because this is that defense that you're always going to want to be looking for as an employer, is what we're going to call the Eller-Farragut defense. Fast forward to 2006. The woman in the picture there is Tarana Burke. She started the Me Too movement, hashtag Me Too. She started that in 2006, and that was in connection with women and victims of sexual assault. A lot of people think that this hashtag Me Too started with Alyssa Milano in, December of 2017. She just sort of piggybacked on what Tarana Burke had started, and now we've seen the birth of Speak Out Revolution. 2017, 2018, where Time Magazine People of the Year are those who are the whistleblowers. So again, we're here. I think that we're in the post-Harvey Weinstein world, and there is a strong emphasis in the workplace, specifically in the workplace, on harassment and unlawful discrimination. So it's been around. Here's the evolution, but now we're here, and now we're going to talk about, what we're seeing in terms of the increase and what we expect to see. So if you look at leading up to the recent Me Too movement, sexual harassment charges filed were actually in decline. In 2017, 6,696 sexual harassment charges were filed with the EEOC, a 15% drop from 2010. Interestingly, if you look at a 2016 report from the EEOC about harassment in the workplace, that report basically suggested that sexual harassment is significantly underreported. What I think that we will see is after the Harvey Weinstein effect of, late 2017, these stats I predict are going to change significantly. There's such a heightened awareness in the workplace, or even in our popular culture, about inappropriate offensive conduct in the workplace, specifically geared towards women and minorities. So I think that this trend, we are going to see an increase in the number of people reporting harassment complaints. Does that mean we're going to see a rise in EEOC charges? Probably, right? But what it also is going to suggest is we're going to see a lot more internal investigations going on. And just to look at the charge patterns, Sam, I think you wanted to speak about this.
Yeah, exactly. So thanks, John. So as John mentioned here, this chart really lends itself to everything we've just discussed. So you can see sexual harassment charges on this chart represented by the black diamond line. And as you see, those charges have decreased from 2016 to 2017. But what's interesting is when the EEOC made that calculation or that determination, it really only looked to their fiscal year, which ended in October. So as John was opining that these charge filings will likely increase in the next year, that really relates itself to this chart, because if the filings ended in October, that really didn't contemplate all the Me Too charges we've been seeing more recently. So we'll talk a bit later about what that means for the insurance market, but something to keep in mind is if sexual harassment charges are decreasing, that might be a good way to help us leverage the market and potentially alleviate some of underwriters' concerns regarding those sexual harassment charges. So similarly, on our next slide here, we're looking at the monetary benefits obtained from those charges. So the sexual harassment line here is represented by the purple diamond line. And what's interesting is the monetary benefit did increase slightly, but overall, it's not very high up on the chart. There are other causes of action that lend themselves to higher values. And that's really to be expected, because sexual harassment claims are usually individual claimants who are bringing them. So the dollar value is not as large as some other types of claims where you have class situations. The next few charts just show you how large these sexual harassment claims can be. So these are broken down by region. The red states represent the states you would think would be the most plaintiff-friendly, most egregious types of violations there. So this slide in particular supports that, with New York having 2 of the sexual harassment claims, 2 large ones. But again, it just shows you that they happen all over the nation as we go through the next couple of slides, and not solely in one region. So here you see Illinois and Texas, states with very dense city centers. So of course you're going to get aggressive plaintiffs' counsel, to be blunt. We have the Western region here with a couple of cases, and of course California always being the star of the show with a significant number of cases coming in. So then here we're looking at the gender pay gap. So given the heightened focus on sexual harassment, that may lead to a heightened focus on the gender pay gap. And this chart only looks through 2016, but you can see the gender pay gap has been decreasing over time with a lessening in the disparity of 0.9% since 2015. So some states, in response to the gender pay gap, are trying to make strides more quickly. So if we look at states like California, they have an act, the California Fair Pay Act, in place, which requires employers to not ban wage disclosures. So in actuality, that might put instances of pay disparity out into the open, so people start talking about that. We also have seen out of the UK specifically that they are tracking data for pay differences. So it'll be interesting to see whether or not the international community starts combating this more forcefully and reaching a better or smaller deficit or deficiency than there is in the US. And with that, I think I'm going to turn it back over to John to give us a more in-depth overview of sexual harassment.
All right. Thanks, Sam. So this is the lawyer part, but I'm going to make it as sort of as painless as possible. But I think it's important that, you know, I want to really talk to everyone about risk avoidance, right? Aon's going to, and Sam and Tom are going to talk about risk transfer, but my piece that I want to focus on is risk avoidance. And I think you got to start at the beginning. What is sex discrimination? What is sex harassment, right? Is there a difference between the two? So when we're thinking in terms of discrimination and harassment, I like to think of an umbrella, an equal employment opportunity umbrella. And there are tons of things under that umbrella. You know, there's affirmative action, there is pay equity, there is all these things, but on all these concepts, right? So sex discrimination, or just discrimination, and harassment, I really treat those as two separate things. When we talk about discrimination, right, the definition of discrimination, really what I like to say, it's tied to something. If you are going to make a claim that I'm being discriminated against, or if somebody's going to make a claim against your company that they're being discriminated against, that discrimination really needs to be tied to what we call a tangible employment action. So for example, I was not hired because I'm a man. I was terminated because I was a man. I did not get a promotion, or I did not get a raise, or I got a very poor performance review. Those are tangible employment actions, right? Because of my race or gender, I didn't get this workplace benefit, right? So it's very simple, right, when you think about discrimination. It deals with promotions, evaluations, discipline, everything. And it's not just about sex. We're going to focus today on sex, but there is also, you can be hurt, you know, there's discrimination claims based upon all these protected categories. We have race, color, national origin, genetic information, religion, age, disability, right? I like to say that, you know, under the EEO laws and discrimination, you have to treat everyone the same. Except there are two areas where you kind of have to treat people a little bit better, and that's in the areas of disability and religion. There's a concept of reasonable accommodation, and employers required to reasonably accommodate disabilities and religious beliefs. That's not the focus of today, but those are just two areas where you kind of have to treat people a little bit better. So it's not true, you know, the playing field is not completely level. There are requirements as employers of types of accommodations that we have to provide to those employees. So that's discrimination. It's tied to a promotion or some type of workplace benefit. Harassment's a little bit different, right? Let's think back to the things that Anita Hill discussed on Capitol Hill in 1991, right? What she discussed during those confirmation hearings were about Clarence Thomas and some of the things he said to her that were sexually inappropriate, that he may have regularly asked her out on one-on-one dinners and dates, right? If we're looking at the context of what Anita Hill talked about. And if we look at recent, I mean, it's all over the headlines. Senior executives at major corporations are dropping like flies, right, in connection with allegations. If we look at what those allegations all are, not many, few if any, are related to I was terminated because of this, right? What all of them really do is they deal with and they talk about how somebody was made to feel at work, right? So there's not this tangible employment action. These are all about the environment, right? The environment was sexually charged, or the environment was, condoned, the environment was very racially charged, and there were negative comments in the workplace made about certain minorities, right? So it's about how you're made to feel based upon the workplace. Here's the legal definition of sexual harassment. Two types. So there's the classic quid pro quo sexual harassment, which refers to if you have go on a date with me or enter a relationship with me, I will give you a raise or a promotion. Literally, quid pro quo means this for that. That's one type of sexual harassment, right? So if, you're a supervisor and I ask, and I offer you opportunities, but in exchange you have to give me something, that's quid pro quo. That's classic sexual harassment. Hostile work environment is what I'm talking about, and that's really what we're seeing a lot right now. A lot of the internal complaints that I'm dealing with clients deal with the hostile work environment claim, which is very specific. A hostile work environment claim generally has three elements to it. One, the conduct has to be offensive. Two, the conduct has to be unwelcome. And three, the conduct has to be severe and pervasive. And a hostile work environment, when you're talking about quid pro quo, it has to be a supervisor-subordinate situation. But when you're dealing with hostile work environment really deals with, it could be coworkers, right? It could be anyone. So when you're talking about offensive, right? Offensive or inappropriate conduct, I don't know. Everyone always asks me whenever I do this training, I do a lot of training. Well, how do you define offensive? Again, it is like impossible to define what offensive is, right? We generally all have an understanding of what's offensive, but I like to say, listen, pretend throughout any day that you have your father, mother figure on one shoulder, your significant other on your other shoulder, and if you have kids, your kids are on your back, right? So throughout the day, you have those three areas, those three individuals constantly with you throughout the day at work. If you say or do anything that you wouldn't want any of those three people to hear, then don't do it. That's like the best example that I can give and the best definition, right? Because when you look at offensive, I mean, obviously talking about sex in the workplace for the most part, or anything crass is offensive. But when you look at offensive, the law says, well, offensiveness is determined based upon a reasonable person. What is a reasonable person? These are like the $1 million questions. This is why people don't like lawyers, because they're the ones who create these standards. But a reasonable person, I mean, again, the spectrum of what's reasonable, right? If you're looking at, what offensive is on a spectrum, you could look at, everyone knows that person who is offended by everything, right? Anything you say, you look at them, a little bit to the left and they're offended. And then on the opposite end of the spectrum, you may have in your employ, a 25-year-old male who just graduated from college, and he was in a fraternity for 4 years, and nothing either disgusts or offends that person, right? So you have that spectrum. Who's to say what's offensive? So again, if you, really talk about what's offensive, I like to say, especially in this day and age, virtually everything is if you're talking about sex, politics, and religion in the workplace. And one important thing is that it's not whether I had an intent to say something offensive, right? It has nothing to do with the person's intent. What the law looks at is what's the impact on the person observing or subjected to that type of conduct. The second piece of a hostile work environment claim is unwelcomeness, right? So the conduct can't be solicited. For example, if I'm asking out a subordinate employee on a date and via text message, and I say, let's meet for lunch later on, and that employee texts me back and says, LOL, winky face emoji, I'll see you later. And then that person later on brings a claim and says, well, he kept asking me out on dates. The unwelcomeness is not there, right? Because when you're sending those types of text messages, it's suggesting that you're a participant in this type of conduct. So again, it has to be, you can't be a willing participant in it, right? And then severe and pervasive. So the last piece of this to prove a case under the law is severe and pervasive. One, if there's a sexual assault or any inappropriate touching in the workplace, you're at severe and pervasive. But severe and pervasive really is, it's got to be kind of bad, right? So when you're thinking about it, it can't just be one inappropriate comment. That's not going to violate the law. The standard of hostile work environment under the law is pretty high, unless you're in New York City where the standard is much lower, or in California where that legal standard is much lower. But again, to prove a hostile work environment claim under the law, not the easiest thing to do. But what do we do as employers? As employers, and we'll talk a little bit more about what should be in the content of the policy, employers are advised to have workplace policies that basically prohibit any type of inappropriate conduct, right? So we never want to get to severe and pervasive. One comment, everyone, employers' policies should say we do not tolerate any type of offensive conduct in the workplace, and even one comment could subject somebody to discipline and up to, including a termination. It's important that in the world of sexual harassment, we know that anyone could be a harasser, right? So if, when you're dealing with quid pro quo or with discrimination, it has to be an employee discriminating or even harassing someone else. But when you're looking at harassment, it's not just employees and supervisors. It could be anyone, right? It could be a vendor. It could be the FedEx guy that comes to the office and interacts with your receptionist. It could be a client. It could be a vendor, right? So one thing that we have to understand is, and where a lot of claims I see coming up now are not just complaints driven by employee behavior, but it's complaints driven by third parties, right? Third parties doing offensive things. And this is the interesting one that I think opens a lot of eyes whenever I conduct this training is harassment can occur anywhere. It's not just within the four walls of your offices, right? It could be at that holiday party. And I always dread holiday parties because that's usually where most problems start. Anytime that you introduce alcohol in the workplace, it's problematic. Let's say it's a holiday party, right? It could happen there. Somebody comes into work on Monday because they're uncomfortable about something that happened over the weekend at a work event. Yeah, that's a problem. Off premises at private sites, right? So think of 3 employees that you have. 3 employees go out for drinks on a Friday night after a long week at work, and something inappropriate happens. Somebody comes to you on Monday, and somebody comes to the employer on Monday and says, listen, I feel really uncomfortable. We went out for drinks on Friday night. It wasn't work sponsored. There were no supervisors there. Is that still a problem for the employer? Yeah, it is. Right? So just understanding and educating employees on, the breadth of any type of non-harassment policy. Most importantly now, we're in the world of social media. So it extends to there as well, right? Employees can violate the policy or harass one another via social media sites like Facebook or Instagram. We had a situation, I had a client 2 weeks ago where they asked, do we need to act on it? It was, a male employee had access to a female employee's Instagram page. And he commented on one of her pictures that, she looked smoking hot, right? And the employee didn't come forward, but the supervisor, was, friends with these 2 individuals on Instagram. He noticed the comment. And the employer said to me, do you think I have to act? And I said, absolutely. Right? Are we talking about things inappropriate in the workplace? Right, absolutely. If we're aware of it, I think it's something that we should just at least, every situation is different, right? But we should at least be aware and conscious that things that are occurring on social media may violate the policy, may be a problem. We can't just turn our heads the other way. Interesting liability standards. So if you're looking at quid pro quo harassment claim, the employer, right, if you have a supervisor who's stupid and, tries to, harass an employee, right? If it's a supervisor doing it, it's strict liability for the company. That means we have no shot of winning. Your lowest level employee, your lowest level supervisor is an agent of the employer, right? So even if they aren't senior in the organization, they still speak on behalf of the organization. Strict liability for any supervisor. Hostile work environment, a little bit different. Hostile work environment, if it's a supervisor creating that environment, is strict liability. And when I say strict liability, it means when you're looking at a claim, somebody brings a claim, there's 2 phases. There's liability and then there's damages, right? So strict liability means we're liable no matter what. We have no defenses. The question comes as to whether or not how much damages we're going to be required to pay. So strict liability is pretty scary, especially when you're thinking about managers in your organization who are holding you strictly liable for them. The other standard is if it's coworker harassment, right? If it's a coworker or an outside vendor, there's a negligence standard. And really what that standard means is, did the employer take reasonable preventative steps to make sure that harassment didn't occur? And I like to say that's where your HR departments come in, right? And that's if you have an employer that has an HR function, you have a well-written and well-distributed non-harassment, non-discrimination policy, and you train your managers, all of that assists in the defense of those coworker harassment claims, that negligence standard. Now, all is not lost in terms of the strict liability for supervisors, where sort of the preventative practices, the training, the HR department, the policy, where all that helps out in the strict liability situation is it helps out in damages. Right, it helps out mitigate some of the damages. We have seen an increase so since 1964, when you look at the types of charges and lawsuits filed in the United States, since the Civil Rights Act passed in 1964, race was always the #1 claim filed in the United States, up until about 2 years ago. Retaliation now is the #1 claim. This is the #1 risk for employers, right? The #1 claim filed in the United States. And there's a reason for it. The standard, it's much easier to prove retaliation than it is to prove discrimination. What's retaliation? Retaliation is after somebody complains or they're involved in an investigation regarding a discrimination or harassment complaint, that's protected activity. Right? Somebody engages in protected activity, and after that protected activity, the workplace changes for them for the negative. So if we look at the legal standards, why attorneys love this, is that the standards basically are under discrimination. If you're going to bring a claim of discrimination, the standard, you have to have some sort of tangible employment action, right? I was terminated. I didn't get a promotion. But when you're looking at the legal standard for retaliation, the legal standard for retaliation, basically summarizing it, is I wouldn't have complained had I known I'd been treated this way. So the situation where a supervisor says, you know what, this person complained about me, I'm just going to avoid that person. Right? That could be the basis of a retaliation claim. Transferring an employee to a different department to avoid the supervisor that he or she complained about, that could be the basis of a retaliation claim. So the standard is easier. You know, I spend a lot of my time litigating employment discrimination lawsuits, and one of the issues that I always find is I usually can defend, and I know folks at Aon could agree with this, you could usually defend the underlying discrimination claim. That's not your problem. More often than not, I find myself chomping at the bit and really dealing with the retaliation claim, right? Because the legal standard is a lot lower, but let's just think about retaliation, right? Let's think about the natural emotional reaction to somebody complaining about you. I like to say, listen, if somebody were to complain about me and say, the reason why I didn't promote somebody, or the reason why I did something was because of some discriminatory reason, because I don't like minorities, or I don't like men, or I don't like women. When you think about it, what's the natural reaction to that complaint? The natural reaction to that complaint, and you learning about it, is you become defensive. I'm going to be honest with you, I'd be angry. Right? I think I like to hold myself that I treat people that, you know, I base all my decisions upon performance and merit. And I think most people would be offended, would be mad that this person's complaining about them. So you couple the lower legal standard with the natural response to somebody saying that you did something or discriminated against them. That's the makings of a retaliation claim and why they're so prevalent. Plaintiffs' attorneys love the retaliation claim because they know it's much easier to prove. And employees find themselves in a very difficult situation if somebody brings a retaliation claim. And it's even more difficult, and the most difficult, if that retaliation claim is made while the employee is still employed. Anyone on the line who has actually experienced an incumbent employee complaining about discrimination or harassment in the workplace knows that that is an extremely difficult situation to manage. Turning now to sort of the scary part, remedies, right? The damages. What can somebody recover in one of these discrimination or harassment lawsuits? And when you think about it, it could be pretty significant. So the damages available in a a harassment or discrimination claim. So the remedies are reinstatement, back pay, and reinstatement is not frequently an option, right? If anyone has ever been in the midst of a settlement or negotiating with an employee who has a claim, or former employee who's had a claim, reinstatement, I think, is often a recipe for disaster. But again, that is an option. But if you're looking at economic damages, back pay and front pay, we have emotional distress damages, punitive damages, attorney's fees and costs. So let's just run some quick numbers. So let's say that you have an employee that was terminated, they bring a claim, that employee was making $50,000 a year. I'm terrible at math, so I'm only going to use round numbers. So if you're going to do an economic damages calculation, typically you look at back pay and front pay. And usually the way the back pay is calculated is from the date of separation through the date of the proposed trial. The courts are really busy in the United States. I usually say a back pay claim is about 3 years. So right now we're at $150K in back pay damages. Front pay. Front pay basically is at the time of trial, how much longer will it take for the person to get a job? More often than not, you will see courts awarding front pay for 1 year. So we're at $200,000, right, if there's an award against an employer. Then we come to emotional distress damages. Let's assume that the plaintiff who won this case now had no mental health issues prior to the alleged discrimination or harassment, rank and file person without mental health issues. Typically, courts usually award around the value of the economic damages. So for a plaintiff that doesn't have a past history of mental health illness, add on another $200K. So now we're at $400K. If you have the unfortunate situation where the person that wins a discrimination lawsuit has a long history of emotional distress issues, and we made it a lot worse because of what happened at the workplace, that $200,000 goes through the roof. There's no limits on what that could be. But for purposes of our mathematics here, we're just going to talk about somebody who doesn't have that type of mental history past. Punitive damages, uncapped. Punitive damages are punishment damages, and I'm sure Sam and Tom on the line are talking about that. More often than not, most insurance policies don't cover punitive damages, right? This is where it can be very frightening. So punitive damages basically are punishment damages. You, employer, did nothing to remedy the situation. For example, punitive damages often are assessed in cases where an employee complained repeatedly but nothing was done. That's a situation where, and you're seeing that now. Look at all the people, the Weinstein company is now just been, a claim was brought against him from the New York State Attorney General's office, right, for failure to do anything. That's where punitive damages come into play. Punitive damages also come into play when an employer doesn't have, a well-written or well-established anti-harassment policy. It's essential, if you're ever going to fight a punitive damages award claim, it's essential that you at the bare minimum have a policy that's distributed to your staff about the company's prohibition against discrimination and retaliation in the workplace. So punitive damages, let's just say it's an employer where doesn't have anything. You don't have anything. You didn't investigate the complaint. You don't have an internal complaint procedure. You don't have a policy. 2 times the economic and compensatory damage is a typical number. So now we're at $800,000, right? And we haven't even gotten to the best part. Attorney's fees. So unlike most other laws in the United States, the civil rights statutes actually have a fee shifting provision in them. In 1964, really what we wanted to do, Congress wanted people to bring forward complaints. Now, the United States is typically everyone pays their own attorneys. That's generally the rule in the United States. But for the civil rights statutes, and it's the same thing under various state laws, under these civil rights statutes, if you are the loser employer, you have to pay attorney's fees, right? So if you're looking at attorney's fees for a prevailing plaintiff's attorney, looking at cradle to grave from when a lawsuit starts all the way to the end, I've seen fee awards, and again, throughout the United States, it's obviously going to be more in California and New York where the hourly rates of attorneys are typically higher. But if you're just looking at a blended rate, a blended number, I think $300,000 is a reasonable estimate for plaintiff's attorney's fees in a lawsuit. So we're already at $1.1 million, right? And there's one thing that I didn't include on this list. You haven't paid your defense counsel yet. And so everyone's gasping on the phone thinking the attorneys are taking everything. This is why people don't like attorneys. But you haven't even paid your own defense costs, right? So if you're looking at these numbers and, looking at defense costs, let's just mirror the same exact attorney's fees provision for your own attorneys. So you're at $1.4 million, right? So an employee who is making $50,000 a year is terminated and or subjected to a hostile work environment quickly can turn into, if we've done nothing to mitigate this risk, into $1.4 million. It gets even better. So the tax code, I'm not a tax attorney and I'm not going to be able to really go into much detail about this, but one thing I do know, the tax code that recently was changed, believe it or not, I couldn't believe that this was part of the tax code. But basically, the tax code has changed, and if in the past, if you had a judgment or if you had a settlement, right, the settlement value for a sexual harassment lawsuit is a business loss, right? It's a write-off. However, when the new tax code changes came into effect, they basically said, if you are resolving a sexual there was an award for a sexual harassment and the allegations were sexual harassment, and there's money being paid by the employer for that sexual harassment claim. If there's an agreement in place that requires the employee to keep the monetary value or the case confidential, which anyone who's ever seen a settlement agreement always requires that the money and the amount be kept confidential, the employer cannot use that as a business write-off. So again, we're seeing this even at the federal level on how, just how expensive these cases can be, and employees cannot use them as a write-off. Not that that was, a reason, not to prevent these types of claims, but again, we're seeing a big, big change. Let's talk about how you prevent this. The first thing, and the most important thing, is that employers really need to have effective harassment and discrimination program in place. I'm not just talking about, here's a policy buried on page 25 of our handbook that hasn't been looked at in a long time. It's 5 sentences and talks about how we prohibit discrimination and harassment in the workplace. That's not enough. That's not going to free you of punitive damages, right? So really what we are recommending, what Jackson Lewis recommends, and most, management side attorneys will recommend, these are the components of an effective program, right? Everyone must have a policy, right? A written policy. And we'll talk about sort of what I think the content of that policy should be. The policy should be disseminated, right? I like reissuing the harassment policy, the non-discrimination policy, maybe your code of conduct, electronic communication, the really important policies. I mean, those should be distributed every year, right? Redistributed, even if it's just an email sending it out to people, reminding them of the company's policies. I believe that a truly effective program to avoid harassment and discrimination in the workplace and to mitigate certain damages is training, right? At a bare minimum, supervisors should be trained on what the harassment is. And then there needs to be a very strong complaint procedure, right? Most organizations should have somebody who is trained or responsible for investigating complaints of discrimination or harassment. Here's the policy essentials, right? If anyone is looking, this is a great sort of checklist. If anyone's taking a look at their non-discrimination harassment policy, these are the contents. I don't like generic policies, right? I do have clients and I do have sort of a form that I would start from, but I don't think it's good for any client or any employer to just have a standard stock non-harassment policy. I think the harassment policy really should be geared towards the workplace, right? So I like examples. I always put examples in harassment policies, and I sort of speak with management and speak with HR and say, listen, let's talk about your work environment. What are some things that may come up or have come up, right? If you have a very manufacturing-based environment, right? Some of the things that come up in a manufacturing-based environment are going to be a little bit different than something that comes up in, let's say, an IT tech environment where you have most of your employees are some type of IT engineers, right? So when you really have to take a look at the workplace and make sure that the policy really speaks the language of the employees. And when I say speak the language, I also recommend that if you have a staff that predominantly speaks another language, right? Not required by law, but let's say that you have a large staff that speaks Spanish. I recommend that, it'd be great to have your whole policy manual translated to Spanish, but at a bare minimum, if you have a large population whose primary language is Spanish, I totally recommend that everyone have their non-harassment discrimination policy translated into Spanish. It's not a large undertaking, right? But that goes a long way to show how far you've gone in order to educate your staff about the policies and the prohibitions against discrimination. Every harassment policy really should cover, what I talked about earlier, who could be a harasser. If it's clients, if it's vendors, any other third parties, examples in there to talk about, if you are a client services business and you have employees regularly interacting with or even going into clients' work sites, it's important that your policy really talk about and say, conduct by clients is still inappropriate. Bring it to our attention. You also want a complaint procedure with multiple avenues for complaint. I hate those policies that say you got to complain to your immediate supervisor, or the only person you can complain to is the president of the company, right? When you look at that, what if it's a supervisor? What if you're a lower level employee? I have to go complain to the president of the company? I'm not confident enough to do that. Or those policies that say you are required to submit your complaint in writing. Those are not good, right? Because what is the effect of those types of stringent policies? The effect of those types of policies and complaint procedures is basically chilling people from coming forward with complaints. If people don't feel coming forward with complaints internally, where do you think they're going to go? They're going to go to the EEOC. They're going to go to plaintiffs' lawyers. So I always like in my non-harassment policies to include a provision that says, listen, you can complain to your supervisor, you can complain to human resources, or you can complain to any other member of management with whom you feel comfortable. Now, again, I typically don't have that last clause, any member of management with whom you feel comfortable, unless you've done management training. Management training is important. We're going to talk about that because really all of your supervisors should be trained on what to do in response to somebody bringing a complaint. And when you have that open door of complaints, yeah, you might see more complaints, but I don't think that is necessarily a bad thing. The one thing that I'm seeing now, I haven't seen yet the sort of the huge increase in sexual harassment lawsuits yet. I don't think we've seen that yet because it takes a little while for the lawsuits to shake themselves out or to come to fruition. What I'm seeing now, what I'm constantly counseling clients on, and I'm sure everyone on the line can attest to this, there's been a huge increase in the number of internal complaints. Every client now I'm getting calls, and one of the biggest issues is conducting workplace investigations, right? I cannot corroborate the allegations. What do I do? Right, so that's a big thing that we're dealing with now. I think that's the quiet before the storm. You're going to have the internal complaints, and then the EEOC charges will start building up, or the lawsuits will start building up sometime after this, when people become dissatisfied with the results of the investigations. Focusing now back to the contents of a policy, must mention anti-retaliation. I like to put anti-retaliation, sort of separate from the body of the policy and the complaint procedure. And I like to have it in bold and talk about non-retaliation and give an example of what retaliation is. And not just retaliation against people who complained. The retaliation provisions also extend to those individuals who investigate, who are involved in an investigation or participate in that investigation. So for example, we want employees who were asked questions about whether they observed harassing conduct. We want those employees to be protected too, because the law protects them, right? So we want them to know that, listen, if you corroborated and you supported your coworker who claimed that the supervisor sexually harassed them, the supervisor is now ignoring both of them, even the person who participated in the investigation. That's a problem. That's a retaliation. That's exposure to whatever, to your company. Specify that perpetrators will be disciplined, and those who fail to report also may be subject to disciplinary action. I always like to include in the policy that employees who are found to have violated this policy will be subject to appropriate corrective action up to including termination. And that also discuss this piece of it's interesting. Everyone has a duty to report. I like that in non-harassment policies and discrimination policies. I think everyone should understand that they have a duty to report. You see something, say something. I know people on the line are saying, well, why would we want to hear all these? Why would we want to educate people and have them bring forward these complaints? Circle back to what I just initially said. It's so important. We'd rather deal with these complaints internally because we can deal with them. We can make sure it doesn't happen again. We can discipline people. That saves us, right? If somebody wants to go bring a lawsuit and they never complained internally, there's defenses to that. And that's sort of embedded in what I initially was talking about was the Yeller-Farragut defense. Comply with state-specific statutory requirements. It's really important that, there's federal law that has non-discrimination requirements, but every state has their own civil rights statutes. And the definitions vary, right? Because states are very different in terms of what legally protected characteristics, what are protected under certain laws. You know, what's protected in New York City is more likely than not protected in Texas, right? Because the federal law has prohibits discrimination on certain categories, but the states and cities are free to have additional protected categories. You know, so for example, New York City has victims of domestic violence, right? That's a protected category. That is not a protected category under federal law. So we want to make sure that we have some type of state or city level review. And I mean, in some states, for example, Massachusetts has very specific requirements of what need be included in a non-harassment policy. I believe in Massachusetts, you have to include information regarding the EEOC. So again, it's important that we have these policies, we look at them from a federal perspective, we also make sure that we're complying and we have information that's required on the state level. And the last piece of this is language, right? What does your staff speak, right? If, like I said, translating it, not a lot of money, but goes a long way in educating your staff on what the policy is. Let's talk about dissemination of the policy. A great written policy does very little if it's buried in a handbook somewhere, right? So I think at the time of hire, I often like to have a non-harassment policy. Yes, you have it in the employee manual, but also have it separate and have a sign-off, right? Say, I have a copy of the policy and have the employee sign off on the bottom that they received it. You know, you give them 2 copies, they keep one, and you have the signed copy, right? I like that. Definitely at the time of hire. I like it annually to remind employees of their obligations under the policy. It should be disseminated from leadership, right? It should be the HR director or, you know, the president of the company. Depends on what your company structure is, but it should come from the top. It means a lot more when the person disseminating the policy is somebody in a real position of power that employees respect. If you are an employer that has town hall meetings, you know, I have a lot of employers who, in the wake of the Harvey Weinstein scandals, basically there was nothing internally going on in the organization, but senior management said, listen, I want to address this issue. I want to remind everyone during our town hall conference call that we have once a month about our non-harassment policies. Great idea. Posters, right? You might want to have, everyone should have their posters and postings in the workplace. That's where you remind people of the non-harassment, non-discrimination provisions. And you want to make policies accessible to employee after dissemination. Right? If we give hard copies of the employee manual, I think it's really good to have the non-harassment, non-discrimination policies available to employees at their fingertips, whether it be on an internal portal. But if you have employees that don't have access to computers and you're in a manufacturing setting, you know, maybe have copies of the policies outside the supervisor's office, right? That's so that employees always have access to it. This is just, you know, the icing on the cake. This is, you know, the A+ client. And an email from senior management, you know, to, you know, all of their employees, reminding them that the company prohibits discrimination and harassment based upon, you know, whatever protected category. And this email, and everyone will have access to the slides afterwards. But I love this email. This really comes from the top, really sets the tone and culture of a company that prohibits discrimination and harassment in the workplace. An employer that disseminates the policy and that reminds employee of the policy, I'm telling you, you're going to get less claims and you're going to have better defenses when those claims come up. Training. The second piece of this important relationship is everyone should receive training. I'm such an advocate for training. If you have boards of directors, a lot of questions that are coming up, every client that has a board, one of the big questions that all the boards are asking are, what are we doing in the wake of all of these new claims coming against employers, right? Training. Besides your policy, training. Train your board of directors. And this is different types of training, right? C-suite executive, right? Your C-suite executive leadership stream, that training is going to be different than your rank and file employees, right? C-suite definitely needs to be trained. Non-executive management, this is where I get the most concerned and where I think if an employer is looking at where do I have to spend my resources, it's non-executive management training. Those are your weakest links. They are, under the law, they are the agent just as your CEO and CFO is. Right? And I know people are now sitting on this webinar thinking, oh my gosh, I know my mid-level manager that I'm frightened about the things that they will do and say. They're your biggest risks. That's where I invest the most time in terms of training, right? And I'm going to go through briefly what the training should include. And human resources, non-management employees should have training. And then the human resources department, right? Or your compliance people, legal, they should be trained, but it's all different training, right? All different types of training. You should use qualified instructors, and it's different messages for different groups, for everyone. This is what I recommend for all employees. The most important thing, non-supervisory employees, I like to say the employees need to know about the company's commitment to discrimination, to non-discrimination and non-harassment, and they need to know about the company's complaint procedure, and they also need to know about retaliation and consequences of violation. This is the basics. This training doesn't have to be 2-hour training. This could be a 20-minute training distributing the non-harassment policy and explaining the highlights of it. Your HR people can do this internally, right? Your supervisors, if we have confidence in them, can do this. Managers and supervisors, this is where I would spend the most time. This is where the training really is what I like to call the supervisors scared straight, right? We want to teach them about the policies, their obligations, what are appropriate responses to complaints and issues, right? They need to be trained on how to deal with these things, because at the end of the day, they're speaking on behalf of the company in what they're doing. So again, this is where I see most of the slip-ups. This is where I see the most weaknesses with your lower level, mid-level management. That training for them should talk about accountability for violations. When I do training for supervisors and I let them know that under most states there's individual liability for discrimination or harassment, or failing to act in the wake of discrimination or harassment, everyone who is sleeping before I start talking or while I'm talking wakes up when I mention it's their house, it's their assets that are on the line if they are engaged in this type of conduct. So again, that really wakes them up. They should all be notified. The supervisors should know that. What happens if they fail to report? Advising supervisors that, human resources or senior management is there. It's important that this is where I'd invest my time. Now, one last thing for the training before I bring it back to Tom and Sam is, these are the things that are important to help avoid risk. These programs, right? If we have our policies, if we have the complaint procedure, that's the purpose, right? The purpose is preventative practices. We're gonna move on to what you do if you're already in the soup. But a lot of it is reducing liability is really based upon what things can we do internally. More often than not, I've heard it 100 times. Well, if we really talk to our employees about this, it's just going to increase the number of claims. Why would we want to draw attention and the spotlight onto these issues? I have never seen an employer conduct training, then have or roll out its non-harassment, non-discrimination policies on a regular basis. I have not had a client in 15 years of practicing say, after we did that training, 5 employment lawsuits were filed. Yeah, you may get a little uptick in terms of what is internal investigations or internal complaints, but you deal with those, right? And it's better that you deal with those right away. So, I focused on the preventative stuff, and if I'm reading the tea leaves, I do believe that we are going to see an increase in the number of sexual harassment complaints investigated. I do believe the EEOC is very interested in this. So when the cases of charges are filed with the Equal Employment Opportunity Commission, they're really going to investigate. And I guarantee, and I've already seen it, in connection with a sexual harassment EEOC charge, what the EEOC now is doing is they will send you the charge and ask you to respond via a position statement. But now every EEOC charge that's requesting a position statement also has attached to it something called a request for information from the EEOC that employees are required to respond to. If anyone has seen those requests for information, every single one of those requests for information asks about information about the policies and also asks for information regarding the training. The assumption at the Equal Employment Opportunity Commission is that employers are already conducting this type of training. So again, preventative stuff. Posture yourself in the best place possible to defend these types of claims. And again, my contact information is here. If anyone has any questions, feel free to shoot me an email, if you have anything more specific to ask. And now I'm going to turn this over to Tom and Sam to talk about risk transfer.
Great, thanks, John. And so this next section, again, we're going to kind of get into the insurance a little bit to kind of explain how it operates, what's going on in the marketplace a little bit, and what other tools are available when you do actually purchase the insurance. So with that, if we can kind of go to the next one here. Yes, so again, keys here, this is how claim is triggered, which triggers coverage under the policy. The key with this definition in the policy is a couple of things. One, you want to make sure that, that the coverage is triggered early on. So you're eroding the retention. You're able to kind of take advantage of the policy's terms and conditions as early as possible. So this is a very broad definition of what triggers the policy, what triggers coverage. The flip side of this is, for those of you that already have insurance, it also is very mindful that you think that this broad definition is also when these things happen, you need to be alerting your carriers to that event. So it could be as much as a letter from an attorney alleging sexual harassment, even an internal written demand for something could trigger the definition if they're alleging a sexual harassment claim. It obviously can be an actual lawsuit. It can be an arbitration proceeding. It can be the charge with the EEOC. It can be a lawyer coming to you and saying, hey, let's talk for a while, but while we're talking, we want to toll the statute of limitations to prevent their rights from lapsing. They're very minor events in some ways, and you may think this isn't important enough for me to tell my insurance company about, but that failure to do so could also have ramifications. So on the one hand, we want to make sure that the definition is broad as possible to trigger coverage and make sure the costs you're incurring erode your deductible, but at the same time, you also then have to be very careful that you're then telling your carrier about things that are going on once these things happen in the actual workplace. So next slide. So again, very similar definition of harassment that we just heard from John are the things that's going on in the workplace. So harassment is both sexual or otherwise. So you could have non-sexual harassment. It can be quid pro quo, or it could be hostile work environment. So the policies are broad enough to cover both of those aspects. And it also, very importantly, has been amended to include things like workplace bullying, which is sort of more of a state law type iteration of sexual harassment. It can also be communicated by social media, on internet sites, et cetera. So the definitions are expanding to adapt to the type of situations we're actually seeing occur in nature, if you will. So again, important that you're paying attention to these things, but more important for your broker to be paying attention to these things to make sure the policy is morphing to address what we're actually seeing in the actual litigation and the actual disputes. So who's a covered claimant is important here because, again, these policies are also equally broad or should be equally broad when you're determining whether the person that's complaining triggers coverage under the policy. So often the definitions can be very complex and they have to work right to make sure that, for instance, if a leased employee or an independent contractor is alleging that they were harassed in the workplace, you want to make sure that the policy is kind of full on responding to that claim. There are reasons why there's differences between an employee complaining versus a third party claiming and how the policies react to them. But the bottom line is we seek to have the full breadth of the types of folks on your work site triggering that definition of employee for who can be a claimant who's alleging they were harmed. And so we work very hard to kind of make sure that definition is broad. But the great thing about the coverage is that it doesn't stop there, right? It is maybe employment practices liability coverage, but it also covers harassment when it occurs against a customer, client, vendor, somebody else that's on your work site that isn't your employee, but still gets harassed by or allegedly harassed by your employees or supervisors, et cetera. So critical component to this, again, these days, the allegations don't stop at just the employees never have. It's very, very common to see harassment against, again, depending on your particular industry in particular, very common to see third parties allege that they were harassed on your work site and seek to hold you liable for that activity. And who's an insured, again, very important. So very broad as well. The entity itself is covered. The employees, the directors and officers, shareholder, if it's the trustees, et cetera, often can be extended out to if they're held responsible for these, sought to be held responsible for these activities, but again, only for their capacity in those roles. So sometimes that can be blurred in these situations. To John's point of talking about, where did this activity occur? There may be some pushback to say, hey, if this was totally off the work site, totally between these folks, unrelated to work, in theory, there could be some efforts to say that wasn't in their capacity. But in reality, we've seen that basically not happen as a significant coverage concern, because it's ultimately what's determined as far as liability. So in effect, if the employer is held liable for the activities of the employee, then it's clearly must have been in their capacity as such to trigger coverage, the same way that the liabilities were found. So, and also important to some degree, again, if any of these claims are brought against individuals, which certainly would be covered, the individual's spouses, domestic partners, et cetera, would also be protected for their estates, if you will, being affected by the loss of the individual wrongdoer. And then another area, again, very similar list here to what John had identified as the type of damages you'll see, and something that feeds into a further conversation about insurability in general, is the broad definition of what's covered under the policy. So all those things that John spoke to about things that could be awarded in these cases are then covered under the policy. So you're going to get your defense costs, you're going to get your actual settlements and verdicts, and then breaking down what those verdicts could involve. Again, the interest, the back pay, the front pay, and the punitives and exemplary damages, as well as the plaintiff's fees, all should be expressly covered under the employment practices policy. So again, very broad definitions that, again, because this is all very intentional activity, it is very prone to getting punitive and exemplary awards, and the policies wouldn't be of much value if they didn't have that kind of coverage baked into them. So good to have that breadth there. So kind of drilling down that a little further is to address the concerns that we sometimes run across with the breadth of that definition of loss. So many states, for instance, California and New York, have either issues with punitive damage coverage or coverage for intentional activity. And obviously, again, as I mentioned, this is all about intentional activity. It's very hard to accidentally harass someone. It's hard to accidentally discriminate against someone. And you want to make sure that the policy is able to respond to both those intentional activities, which could be viewed as uninsurable in certain places, but also then for those states that have issues with punitive damages being insurable, that the policy is able to respond to those as well. So again, very critical area to work hard to make sure your policy, depending on where you are or where you have the potential to be sued, can address these concerns, whether it's through usually a multi-layered effect, sort of like your reporting mechanism. It should be multi-layered, right? So it should have favorable venue wording to make sure that your policy will use the most favorable venue for insurability to allow you to be insured for punitive damages. It should also, that favorable venue ideally should address intentional acts and punitive damages both, because again, both those could be issues. And again, if that favorable venue won't work simply because you're sort of in states that don't allow for the insurability of punitive damages or intentional acts, then there's offshore mechanisms for making sure that the policy can respond either through placing it through Bermuda or through things that are called wraps, to make sure that if the domestic policy for some reason can't respond, that the offshore policy can respond. Just again, if there's just too much likelihood that these issues are going to come up, and it's critical to address them before the claim happens and not scramble to try to correct the problem afterwards. And we often get the question sort of, well, if it's not insurable in my state, then how can I get insurance for it? And the answer to that, in effect, is that whereas it may be uninsurable for the insurance company to offer it in your state if they're subject to U.S. insurance laws, there's no limitations on the individual clients from obtaining insurance for it. The laws focus on the providing of it. And so when we work with offshore carriers, whether it's London or Bermuda, those folks aren't actually subject to the U.S. insurance laws, and they're able to provide that insurance to you and you're not violating the state laws, they're not subject to the state laws. So the mechanisms works to make sure that the policies can respond to address those concerns. The last couple of slides here really, you don't have to get out your expansion glasses here to make sure that you can read all this stuff. This is really just to highlight that another important component of the services offered that come along with the policies are that a number of the carriers actually offer some great risk management services, and Jackson Lewis is very active in providing a lot of these services for the carriers in many situations. There could be everything from training to help with policies and procedures. Sometimes it's a certain set number of time or hotline calls that you can take advantage of. And again, these can be very useful tools. One of the dangers we often see is that when these policies are put in place, that the risk management tools that come along with them kind of get buried in a drawer along with the policy, and they never kind of make it to the people that could take advantage of them within the corporation. So it's kind of a word to the wise to work with your and the next slide is just another example of the additional carriers that provide those services. As you see there. Okay, next slide. And that gets us to our questions section. So if we could open it up for questions, that'd be great.
If anybody has any questions, they can feel free to type them in.
While we're waiting to see if anybody has any questions. Oops, sorry. Go ahead.
Okay, it looks like no one has any questions at this time, so we can just move forward in the presentation.
Great. I'll just make a final comment as far as the state of the marketplace in case any questions do trickle in. And that the only comment there is just that, again, whereas this activity has been rampant in the media, and some carriers are sort of certainly obviously concerned about the exposure, the coverage is still readily available. We're certainly seeing more focus from an underwriting perspective, but it's certainly a very robust marketplace, and we expect to continue to see this as well as other broad aspects of the coverage to be in place for a long time to come.
And this is John, and I just want to add, virtually every single case that we defend is, for the most part, covered by EPL insurance. And I can't stress enough how important this policy is for any employer, just because it creates a sense of certainty, right? If you're handling a case, I talked about that $1.5 million of potential exposure for an individual plaintiff making $50,000 a year, right? So you go into these cases defending these lawsuits in a very different position if you've known that you've done your diligence and you've gotten the EPL insurance, because the policy is fantastic. You know, there are firms, there are firms on the panel that are great. I like to say that because Jackson Lewis is on all the panels, so I'm somewhat self-motivation. But again, that helps out a lot. It controls a lot of the risk for these potential lawsuits. So it's just important. The first thing I always ask whenever a claim comes in is, do you have a carrier? Do you have EPL? Call your broker. Send it off. Maybe there's coverage somewhere. And that really changes the tenet of the conversation when you're handling these cases. So again, I can't emphasize enough the importance of EPL. And what comes along with a lot of them is it's not just the insurance itself. If you look at it and you closely look at sort of the risk management pieces, and I know Jackson Lewis, we have a lot of offerings in connection with the type of risk management services. If you are an insured of certain insurance companies, that there are tons of resources available to you just because you purchased that policy. So, you purchase the policy, but you also get some stuff in there that could help you avoid some claims. So I definitely recommend looking at these types of policies, and also looking at and maybe asking the question, well, what type of risk management services are associated with that policy? Again, again, thank you all so much.
Okay, it looks like we had a question come in. Question is, what difference is there in sexual harassment cases based on work environment?
Mm-hmm.
Office setting, desk setting, NFL locker room, for instance.
Okay, so just looking at, if it's an employer-employee relationship, that is when I talked about hostile work environment and the strict liability, and that's what comes into play. It seems like office setting, dock setting, NFL locker room, for example. I think it may go to, I'm not 100% sure what the question is asking, but I think the workplace extends anywhere. So if you have coworkers in if you have coworkers anywhere, whether it's on the dock or somewhere else, that are working for a company, harassment issues can come up anywhere. It's not just at work. And each work environment is different, right? So if the work environment is a locker room environment, again, the policies and the law applies the same. Again, there's not going to be liability if you,
Sort of gets back to what you talked about as far as the recipient of the offensive behavior. So, where in theory you may think that the dock is going to be more, blue collar, so there may be more willingness to accept some offensive activity. You can't rely on that from a legal perspective. It still gets back to what would be after the fact perceived as offensive.
Mm-hmm. And if you have, I don't know if the question is if you have a locker room in the workplace, if you have a manufacturing setting, you need to make sure that appropriate conduct, there's no boys will be boys or girls will be girls conduct, right? Just because it's happening in a locker room doesn't mean that it couldn't potentially be the basis of a claim.
Right. I think the point was more that, does it change at all depending on what the work environment is? Are you somehow more able to be offensive in the dockyard setting than you are in an office? And I think that really changes in reality.
I agree.
Okay, it looks like we don't have any more questions coming in. That being said, can hand it back over to John if you want to give everybody a little bit more of a background about Jackson Lewis.
Yeah, just Jackson Lewis is a national workplace law firm. We have 57, 58 offices, 800 attorneys. We're everywhere in the United States and in Puerto Rico and Hawaii. And again, all we do is management side employment law. So we never represent plaintiffs. We only represent management. And, our focus is on, we defend lawsuits, but a lot of it is the preventative stuff that we talked about. We specialize in workplace training and anything associated with anything that comes across the desk of an employer dealing with its employees. And these are all our various different practice areas. So it's not just litigation. It's basically anything that would come across your desk as an employer and dealing with employee issues.
Thank you very much. I just wanted to remind everybody on the line that you will receive the presentation slides with contact information for John and Samantha and Tom. And I just want to thank everybody for their attendance. And John, Samantha, and Tom, thank you for putting on this presentation for everybody. I think it was very informative. And thank you all for your time.
Thanks so much.
Thanks, everyone.
Have a great day.
Thank you. Thanks, everyone. Bye-bye.